Supreme Court nominee Elena Kagan. You may know that she has zero judicial experience. She's never worked as a judge. She has spent most of her career in legal academia, but her lifetime legacy of scholarly articles amounts to a stack of paper under 2 inches thick. That's compared to 140,000 pages of political work in the Clinton administration. Plus, another 60,000 of pages she and her supporters won't let anyone see. She spent the next 14 years in academia, mainly at Harvard Law School, where as dean, she famously banned the U.S. military from recruiting through the campus career office during a time of war. She was protesting the Don't Ask, Don't Tell policy law signed into law by President Clinton, and which the military was bound to follow. But she didn't feel so bound. When the law school's anti-discrimination policy conflicted with federal law, she chose policy over the law, a recurring pattern in her career. When she wasn't wandering the halls of academia, Elena Kagan traveled in the corridors of power in Washington. Her 7-year political career started when she climbed aboard the presidential campaign of Michael Dukakis in 1988, and culminated in her job as policy advisor in the Clinton White House. There, she acquired her legal experience as a political lawyer, advising Clinton on such issues as whitewater, aggressive anti-gun measures, affirmative action, and partial birth abortion. The rest of what little we know about Elena Kagan we've had to learn from her carefully limited testimony in her Supreme Court confirmation hearings. And it's not exactly reassuring. She said she'd be willing to look to international law for ideas when interpreting the Constitution.
I guess I'm in favor of good ideas coming from wherever you can get them. So in that sense, I think for a judge to read a law review article, or to read a book about legal issues, or to read the decision of a state court, even though there's no binding effect of that state court, or to read the decision of a foreign court to the extent
but
that...
she's not sure a judge has any business looking to the Declaration of Independence.
So you wouldn't embrace what the Declaration of Independence says, that we have certain God-given inalienable rights that aren't given in the Constitution, that they're ours alone, and that the government doesn't give those to us?
Senator Coburn, I believe that the Constitution is an extraordinary document, and I'm not saying I do not believe that there are rights pre-existing the Constitution and the laws, but my job as a justice is to enforce the Constitution and the laws.
Well, I understand that. Well, I'm not talking about as a justice. I'm talking about Elena Kagan. What do you believe? Are there inalienable rights for us? Do you believe that?
Senator Coburn, I think that the question of what I believe as to what people's rights are outside the Constitution and the laws, that you should not want me to act in any way on the basis of such a belief.
I would want you to always act on the basis of a belief of what our Declaration of Independence says.
Asked if she thought the government could force Americans to eat 3 fruits and 3 vegetables every day, she refused to acknowledge any meaningful limits on congressional power through the Commerce Clause of the Constitution.
The Congress can't regulate non-economic activities, especially to the extent that those activities have traditionally been regulated by the states. And I think that that would be the question that the court would ask with respect to any case of this kind.
Running out of time.
But
I want to give you another condition. What if I said that if eating 3 fruits and 3 vegetables a day would cut health care costs 20%? Now we're into commerce. And since the government pays 65% of all the health care costs, why isn't that constitutional? There are limits on the Commerce Clause of the ones I suggested, which are the ones that were articulated by the court in Morrison and in Lopez, which are primarily about non-economic activity and Congress not being able to regulate non-economic activity. Not that the clause doesn't have any limits, but that deference should be provided to Congress with respect to matters affecting interstate commerce.
It looks like when it comes to interpreting restrictions on congressional power, Kagan would leave the foxes in charge of the henhouse and defer to Congress's own views of its own limitations. So, where do you suppose Kagan stands on whether the government can force people to submit to Obamacare? When it comes to our Second Amendment rights, she said the right thing.
Is there any doubt after the court's decision in Heller and McDonald that the Second Amendment to the Constitution secures a fundamental right for an individual to own a firearm, use it for self-defense in their home?
There is no doubt, Senator Leahy, that is binding precedent, entitled to all the respect of binding precedent in any case. So that is settled law.
Although she wouldn't rule out overturning the landmark Second Amendment cases of Heller and McDonald. And we've heard an Obama nominee say the right words before.
Like you, I understand that how important the right to bear arms is to many, many Americans. In fact, one of my godchildren is a member of the NRA, and I have friends who hunt. I understand the individual right fully that the Supreme Court recognized in Heller.
But Sonia Sotomayor didn't wait very long to show just how hollow those words were when she voted against the Second Amendment in McDonald versus the City of Chicago. Elena Kagan had lots of experience trying to weaken the Second Amendment when she was working with Bill Clinton to tighten gun restrictions, putting policy ahead of the Constitution. Why should she act any differently than Justice Sotomayor once she's sitting on the Supreme Court? While she was working in the Clinton White House, Kagan authored a memo that, for political reasons, softened a medical association's scientific view that partial birth abortion was never medically necessary, this time allowing her policy to skew even the facts. At her hearing, she tried to dodge the issue.
That's my question. Did you write that memo?
I'm sorry, the memo which is...
The memo that basically caused them to go back to the language of medically necessary. That was the big issue to begin with.
Yes, well, I've seen the document, and the document
But did you write it? Is that your memo?
The document is certainly in my handwriting.
The text she added to the medical recommendation was cited repeatedly by courts overturning bans on partial birth abortion and prolonged this gruesome practice for an additional 10 years before the Supreme Court finally ruled that, yes, partial birth abortion bans are in fact constitutional. Her policy position turned out to have no basis in law. So there you have it, what Elena Kagan revealed about her views and what she refused to reveal. The bottom line, President Obama handpicked his own administration's political appointee, Elena Kagan, to follow in the footsteps of his nominee, Sonia Sotomayor, to rubber stamp the policies he knows he'll need an activist Supreme Court to push through. Obamacare, more government, less freedom. The government in Washington needs to return to first principles. As Alexander Hamilton explained when the Constitution was first written, the complete independence of the courts of justice is essential to a limited Constitution. This independence of the judges is equally requisite to guard the Constitution and the rights of individuals. An independent court is a bulwark of our liberty, a guardian of our rights. This president is chipping away at that independence. America deserves better.